Thank you. I was originally going to talk about victims of human trafficking. I think we all come from jurisdictions where we concentrate on prosecuting the offender and we forget about rehabilitating the victim. Our courtrooms are insensitive. I was going to talk about this from I don't think I'll go into the presentation anymore, but maybe if I have time at the end, I may. So basically, my background, I am a judge of the High Court of Malawi and the National Training Director for the Women Judges Association of Malawi, which is the IAWJ chapter. I started off as a prosecutor. I then went into law reform. I was responsible for the program that drafted the Trafficking in Persons Act in Malawi. So I drafted the bill, I did the consultations with the Malawi Law Reform Commission. So my background with trafficking is quite intense. Basically, I have now been asked to talk about organs. And so I'll give some of my experiences with the hope that I can stimulate discussion afterwards on how we can work together in some of the challenges that are presented. So when we talk about organ trafficking in the African context, as we have already discussed, we're talking about witchcraft, we're talking about charms, we're talking about juju. Yes. My experience with this phenomena started when I was a prosecutor. In the early 2000s, we had a very serious case in Malawi where a mass murderer had been going around collecting children's body parts for the purpose of people using them for charms. It was a very sensationalized case, and it was a case on which I learned how to prosecute homicide. So as early as 2000, we have had instances of organs being removed from human beings. But that didn't ignite any special interest in this topic until Malawi finally passed this legislation on human trafficking in 2015. In 2016, for the first time, we had a wave of 107 crimes against persons with albinism. That's from Amnesty International. 19 killings were recorded, and at least 2 people disappeared. In each one of these cases, it was the organs of the persons with albinism that were being required. The response of the Malawi government, because of international pressure and the pressure inside the country from albino associations, was to enhance sentences. So we have an Anatomy Act, which makes it a criminal offense for anybody to sell body parts, but this is really it's a medical law that was used to regulate how you use dead bodies in the teaching of medicine. So all of a sudden, when we found that the criminal code did not have any provisions for organ sale and organ removal, the penalties in the Anatomy Act were enhanced so that anybody who was found selling body parts was now going to be imprisoned for life. The country also responded by drafting and immediately circulating for training a handbook on persons with albinism. So basically, this handbook is supposed to be for prosecutors mostly, but also for judges. It gives you sample charges. I think one of the biggest problems we have in Malawi, and we share this with the many other countries that use lay prosecutors, that use the police to prosecute, is that they struggle with drafting charges. When you have a phenomena such as this, most of the cases will fail because they either charge with a lesser offense or they charge with an offense for which they don't have the evidence to prove. So this handbook actually gives you sample charges. It's a dummy's guide to prosecution, if I am allowed to use that term. And then the Chief Justice also issued a practice direction. Malawi still uses lay magistrates. So for our lower courts, 99% of the adjudicators are persons without a law degree, and they also struggle with certain concepts of the law. So in order to ensure that we are all on the same page and to ensure uniformity, this practice direction said that only those magistrates with a law degree and of a higher grade are the ones that can actually adjudicate on body parts. The sale of body parts in connection with medical advances is not something that has ever been reported. It has been reported, but has never been proved. There was a case some time back where a young boy was supposed to have been taken to Germany for the purposes of removing his kidney for a prominent government person at the time, but that case has never been proved. So basically, I think what we should be, I've been trying to figure out what we're doing here, why we are talking about all these things. And as a trainer, I'll come back to that aspect. The point of view that I'm looking at is this. The Women Judges Association of Malawi has innovated on a number of curriculum, training judicial officers, in addition to what the Ministry of Justice has done with this handbook that I'm talking about. We have designed 2 curriculums and 2 training manuals actually on human trafficking. And our focus has been first and foremost on eliminating gender-based violence, gender-based prejudices. I think the biggest problems that we've had is that our judicial officers will look at a victim and ascribe certain tendencies to them and then judge according to those tendencies. What our training programs do is make you come face to face with your prejudices, see how your courtroom is managed. There have been some excellent ideas around the room about how victims are protected in Kenya, how there are certain shelters that they can go to, how they don't have to come into the courtroom to give evidence. We try to innovate on low-cost ideas on how magistrates can manage the courtroom so that victims don't have to face their perpetrators. One particular case that I wanted to highlight, it happened in Malawi's old capital, Zomba, where it wasn't an albino, but a couple adopted a young boy, 7 years old. They didn't formally adopt him, they just took a child from the village to live with. After a while, somebody offered them 2 million kwacha if they could use this boy's body parts for a charm to make a maize meal, make more money. The couple sold the child, they got the money, the little boy was killed. When the family came back to check on how the boy was doing, they were told he had died and had been buried, but they couldn't show them where he had been buried. So the police came in, and it transcribed after questioning that they had extracted certain body parts from this boy and sold it to a rich businessman. The 2 were arrested. They were convicted by the magistrate who sentenced, it was a brother and a sister. They were sentenced to 12 years and 10 years. They appealed to the High Court. The High Court confirmed the conviction, although the sentences were reduced on grounds of leniency to 9 years, to 10 years and 9 years. Now they are going on to appeal, and the reason they are appealing is they're saying that because there was so much sensation around that trial, the whole town was in uproar, they were going to attack the perpetrator. So the magistrate held the trial in a prison to protect the offender because people were out for his blood. And his ground of appeal was that he didn't have a fair trial because his trial was in a prison rather than in a court building. But that was overturned by the High Court, and he's used the same ground to appeal to the Supreme Court of Appeal. The appeal has not been heard, and the Supreme Court has not given him bail, so which shows us that the grounds are not sufficiently cogent. So anyway, this case also highlights something that somebody else mentioned, and that's about adoption. As a judge of the High Court, I have handled a fair amount of inter-country adoptions, and in each case, indeed, what somebody else has said, you don't know where the child is going. So what I have done, because I was also previously tasked with responsibility for child justice in the country, what I did was come up with some guidelines on how adoption matters should be handled. We cannot, because we are not a Hague Convention country that will follow up to see how the child is being looked after in the country they're going to, what we can do is order a very comprehensive home study before the child leaves, so that we know what country the child is going to. And I'd like, to be able to share experiences with others in this vein. Basically, what we do is we try to get cooperation from the other government, but because we are not a Hague country, they don't often give us the information, and they say, send your own officer. So we will send a Malawian social worker to the house. We will check it for risks. We will check the criminal record in that country. But this is all very expensive, and the expenses have to be borne by the petitioner, which has always brought in a challenge in that if the petitioner is paying the social worker's expenses, to what extent would that prejudice the reporting? Are the children we are sending abroad on the basis of that home study safe? Are we sure that they have reported fairly, knowing that the persons who are paying for the study are the ones who have funded the social worker? We don't have any reported cases of children having been mistreated once they've been taken outside the country. I think although we have a fair number of inter-country adoptions, Malawi is at the lower end. We have about 24 a year. I was looking at other countries that deal with about 2,000 to 4,000 a year. So we're still dealing with small numbers, and we haven't hit the, the danger zone yet. But it's very interesting to note in this debate how do we know, having seen all these media reports on children who are found floating in the River Thames with their organs removed, how do we know that our children don't end up, in such situations, especially in view of organ removal? I'm just trying to think if I still have time to go somewhat into my, in my original presentation. Okay. I'll just have to quickly, I've lost the, okay, I was going to talk about victim protection as a challenge, but I've been somewhat defeated because I've seen how wonderfully Kenya is doing this, and I think all we have to do is learn from them. As judicial officers, because it is, training is my passion, I want to share ideas on how it is that we can work with our criminal jurisdictions that concentrate on punishing the perpetrator. I'd be interested to know how many of us use compensation after we have sentenced the perpetrator. Are we able to fine the accused person and then use some of those assets to bring compensation to the victim? Not so much to remove the traumatic effects of the process that will never be removed, but to assist their psychological recovery and eventual reintegration. I'd be very interested to see how we can innovate and think about the victim from time to time. Our biggest challenge in Malawi is that we have a provision on victim protection, but because of the nature of our country, we have not specified what that victim protection should be. So basically, victim protection depends on the magistrate who is presiding on the case. If an application is made, they have to figure out a way on how the victim can be protected. I've heard very innovative ideas about how people can be moved to safe houses. We have very few safe houses in Malawi, and those that we do, everybody knows about. You can't relocate somebody because Malawi is so small, everybody knows somebody else. Even as a judicial officer, sometimes you're shocked at how many times you know somebody who knows the accused. So for right at the moment, we are relying on restrictions on disclosure. We have provisions that prevent newspapers from reporting on what's going on. I mean, that's fairly standard. Unfortunately, for some reason, when we took these provisions out to acquaint members of the press, they were up in arms. They said, you're curbing our press freedom, freedom of speech. We want to be able to report on anything, which we think is highly unreasonable and cannot be justified under democratic process. But anyway, anybody who discloses the identity of a victim would face prison sentences. The issue that I wanted to point out is, victim protection can only be done with cooperation. I saw a newspaper report once about a girl who had been kidnapped, had been found, and then the newspaper reported to say this girl has been found and is now living with her grandparents in such a village, in such place. I think if we're going to talk about victim protection as a court, how many times are we aware of who is in the courtroom? Maybe just to issue a warning to say, this is a highly sensitive case. Members of the press, you are aware of your responsibility. We have a victim in this courtroom. We also, in terms of gender-sensitive courtroom management, our Criminal Procedure and Evidence Code gives magistrates who are the first instance judges who determine most trafficking cases and criminal cases of this nature. They have the power on their own motion to try cases in camera, to allow the victim to be accompanied by a friend, to allow a petition to be placed between the suspect and the accused. And it's just a simple thing. For those of us that know what a kitenje is, we've had one magistrate that innovated to say when the victim is on that side, there's a screen in between so that he can see the accused and the victim, but they can't see each other because of the subtle messages that they're sending to each other. How do the victims arrive at court? Do they use the same entrance as the perpetrator and his family? those are issues that as judicial officers we need to be taking into account, because if the victim is in any way uncomfortable, they arrive at court at the same time, they're jostling each other in the corridor and offering subtle threats, they will not be able to talk in the courtroom. So these are some of the things that we need to be aware of as judicial officers that will impact on whether victims can give evidence. And you know, I'm just going to end on the note that in most cases, we won't have other sources of evidence except the victim. And if the victim feels threatened in any way, we are never going to have successful prosecutions. So thank you very much for your attention.